So, Alex, a financial advisor and a lawyer walk into a bar.
Oh, then what happens, Dave?
Well, the question comes up, do I really need to update my agreements?
Oh, do I need to update my agreements? Well, you're talking to a lawyer. What do you reckon a lawyer's going to tell you about that?
Absolutely.
And it's going to cost you a ton of money.
Yeah, any way to get some more dough out of you, they're always going to try and suck the life out of you.
Hey, settle down.
Unbelievable. But, seriously, I think from a big perspective, I mean, people do kind of forget sometimes that, agreements like anything need to be updated. It's like, when you're renovating a house or you're looking around your house. I mean, everything needs a bit of maintenance.
Yeah, that's true. As things change, especially when what I find a lot of our clients have gone from being sort of a mum and dad business, if you want to call that, maybe mum and dad and their son helping them or whatever, maybe no staff, and then they've gone over the years, and then they might have 10, 20, 200 staff, and so suddenly their risk profile's changing. They might have had a couple of small customers, and now they might have, $1 million contracts. So as your risk profile's changing, it's a sensible time, and you often then have the cash flow as well to revisit your contracts and to look at your risk management and see if it's all sort of out of kilter.
Yep, but it's also the legislative changes.
Yeah.
In some, even on, for instance, when we talk about employment agreements, I mean, the employment environment is dramatically different than what it was 5 years ago. The obligations to the employer is enormous compared to what it was. And then we've got these issues of working from home, working from the office. How does that work? All of those sorts of agreements. And it's a bit like that refresh. It's like to go back in and qualify, I'm comfortable with that. Or maybe we need to make some adjustments to the way we have our agreements in place. So,
that's true. The legislative changes come along and they can make your whole agreement invalid if you're talking about the wrong bit of workplace legislation or whatever, which isn't going to help you. Or there can be changes which you can exclude certain things that are in the legislation, and the contract has to do that. And if it does do that, then they're excluded, and if it doesn't, then they're included. A big example of that was the Personal Property Securities Register, the PPSA, which was brought in to stop what they used to have fixed and floating charges.
They love all those technical sort of terms, the PPSA.
But that meant if you're a business that hired out equipment and you hired it out and you didn't register your interest in the equipment, and then your customer went into liquidation, the liquidator was the owner of that equipment, even though they'd never paid for it. They hadn't bought it. So not registering on the PPSA had pretty serious consequences for many businesses, and people still don't really understand the PPSA,
especially when you're dealing with some really expensive equipment.
Yeah, that's right. You might be dealing with $1 million truck or a forklift or hugely expensive machinery. We've got some cranes that are worth $2.5 million each, which were being rented out by a client, and registering on the PPSA, which takes like 5 minutes and might cost you $8 or something a registration. So you'd be mad not to register on the PPSA, but you need to know about it, and if you don't get your agreements checked from time to time, then you may never know, and you may be taking risks you didn't know you were taking.
Yeah. So what happens? So if I and I'm going to put myself in as the crane business that you talk about.
Yep.
So I am borrowing money. To purchase that crane.
Yes, exactly.
That crane is then put out to work.
Right.
And unfortunately, the builder that we put it onto goes into liquidation, and I didn't have it on.
Yes.
I, as the owner of the business, I still have that obligation to repay the mortgage, even though the property is now sitting with the liquidator. Do they have an obligation to provide that equipment because the crane would have been held as security on the debt?
Yes, good question. So the primary obligation is you as the business owner who bought the crane need to make to pay for it, regardless of what happens to the equipment. But probably the lender who lent you the money would have a charge over the crane, and probably that would be registered on the PPSA. And therefore, if they did all of that, then the lender would be able to go and grab the crane from the building site right, if it was registered. But, I mean, that's a lot of ifs, right?
Yeah. Yep.
Ideally, obviously, you would register your interest and then you could go and grab it and then you could lend it out to the next person and you can continue on with your business.
Yep.
You don't want to be relying on the security from the lender. But typically the lender, they're not more au fait with this sort of stuff. But it depends on the lender. If you're dealing with a smaller lender, they may not. Whereas you're dealing with a sort of conventional bank, they probably would. But it's certainly a big risk. And we did see it. We've seen a lot of, over the years, we've seen a lot of, particularly construction companies. As we all know, construction's going through a tough time and a lot of them have gone under. And the equipment that was sitting on site or supplies that were sitting on site that hadn't been used yet were all the property of the liquidator. And the liquidator gets appointed and they just sell it all.
And that can go from, a couple of months to years, depending upon how it's sort of set up. I mean, it would be unusual for the equipment to take that long, but certainly there's a period of time that would go through that you're not then generating an income. Yeah,
that's right. And it all comes back to just getting your agreements looked at regularly. I mean, some law firms offer, if they've done an agreement, they'll then update it, if new laws come in. Or if you've got a regular lawyer, and I think if you're a business owner, you should have a lawyer that you use all the time. You should have a regular lawyer because there's a lot of efficiency in having the same person who understands your business and all that. And often they'll offer a service where they'll keep you up to date, for free or for minimal cost in changes in the law that come in, or you'll be on their mailing list and they'll send out articles which you'll ignore or whatever.
I don't think I think, Alex, that's very unfair when you look at, if Taurus Legal Management was sending out
everyone reads
email communication, people would be all over it.
Yeah, all ears. Yeah, I'm not. It's not like I'm on a million email lists of stuff that I ignore. I think I might be on your email list, Dave. But
correct. And he's opened up, but that you hold your breath in anticipation when that pops along.
Yeah. But it's just a matter of going back to having the agreements updated from time to time. And I think looking at the different areas of your business, that you've got agreements with your customers, which are one kind of thing, and they're really important. Your customer agreements are really critical to everything. And that involves warranties, pricing, making sure you've got security for payments, involves personal guarantees if that's appropriate, so that you get paid if the customer goes into liquidation or whatever. And then you've got agreements with your employees, which is another kind of area of risk. And then separately, I think, and this is one that is often ignored completely, which is agreements between business owners. So if there's more than one owner of business who aren't kind of husband and wife, then, or maybe even if they are, they certainly should have a shareholder agreement or a unit holder agreement, some kind of agreement between the owners which governs management, decision-making, voting. It governs what I call the 3D.
Exits, as an exit. Whether that be by choice or life taking its control of you.
Yeah, that's right. Or deadlock, that you get stuck in you've got 50-50 ownership, and so you're stuck and you can't get past a particular decision. And then what do you do? Is there a chairman that gets elected or chairperson? Is there a how do you deal with a deadlock in voting? Do you go to evaluation? Do you exit? Whatever. There's a whole bunch of ways to deal with it all, but having that all in writing makes a big difference. And in fact, in my experience, it even helps the business align. The owners get aligned. Even if you never look at it, even if you do the document and then never look at it again, you may never look at it again if everything goes swimmingly. You don't need to look at it, that's fine. But the process kind of helps the business owners work out, well, hang on, who's doing what, and what happens if we run out of money? Are we both going to kick in 50%? Or what happens if I want to go and you don't want to go, or you get injured? Or, if I pass away, will you be in business with my wife or will the wife?
Yeah. So it's a lot of these what-if questions.
Yeah, absolutely.
So do you think in a lot of respects that for some people, either getting an agreement set up in the first place or a review of their existing agreements is a little bit of, she'll be right?
Yeah, so we certainly have. People are worried. In the first instance, when they're setting up new businesses, I think they're worried about cost, which is understandable when you've got a new business. And you don't have to set this stuff up at the very beginning. I mean, the beginning is very convenient, but you don't have to. And then as the business progresses, they get into a kind of a rhythm, and then they get worried about disturbing that rhythm. And often what happens is, and it's sort of a human trait, I think, is you go, well, I don't want to deal with Dave on that issue about deadlock because that's all a bit tricky, so I just won't. And so then you just put it in the too hard basket. It stays there.
Shove your head in the sand on that one.
Yeah, exactly. That's right. And so that can, and then things can escalate, whereas often if you've got a deadlock break mechanism, even if maybe it's not perfect, at least there's something there, and then you actually avoid the dispute in the first place, because you go, well, look, I know if Dave and I can't agree, I know that the chairperson is our accountant, and I know that they're probably likely to take this view or that view, so I'm going to accept that decision, and it reduces the conflict between you and I.
Yeah, and I think it is that sitting down and having that discussion on any of these sorts of issues. I think we could bring it back to communication, and that will solve a lot of issues in a lot of areas, rather than just avoiding the topic. And again, I think it comes back to, and it's no different if it was your existing directors or shareholders, but also your customers. You don't want to go to the point where you get into a legal argument because you haven't communicated over anything.
Oh yeah, that's right. I mean, we've got one at the moment, which is about uniforms, a school uniform supply agreement dispute, and it just wasn't clear from the contract whether. So a whole bunch of uniforms were manufactured for a chain for a bunch of schools, and it wasn't clear at the end of the contract when the contract finished whether the excess supply of uniforms, and we're talking hundreds of thousands of dollars worth of uniforms, what happened to them? Did the school have to buy them, or did the manufacturer have to bear the cost of making these extras that would then not be used? And there was a real lack of communication. People could see it coming as an issue, but didn't want to deal with it because it was unclear. And then once the contract finished, of course, they're both off lawyers at 20 paces, And as it happens, the school, there's different versions of the school all around Australia, and so we had to deal with it 5 or 6 different times. The same out of date contract that hadn't been revised. Yeah, same issue exactly, and all around Australia for something which there's no inherent, there's no perfect way of approaching it. There should just be some sort of, or maybe you have to buy 50%, or you have to buy them all, and you do, so you run down your supply or whatever. But as you were saying, clear communication would have resolved that from the start.
Do you think that the Australian market is becoming more litigious in that?
Oh, I hope so.
You can just see to our listeners out there, Alex's eyes just sort of glistened, and you can almost see the dollar values. Just he loves it. The more the merrier.
Like America, because that's such a great place to live. Yeah.
But to me, it's just, I know, and look, it's a real balance. Like, it's a really difficult one, I think, because to document everything, some people go, but that's not great. But at the same time, if you're looking to exit your business, if everything's documented, it's very clear, it makes your business more valuable. But also it makes you in a position that then people go, well, if you're going to throw the contract at me, because that's what we've agreed to, then I disagree with that for whatever reason, and I'm interpreting that contract the way it's been written, even though that may have been signed off previously.
Yeah.
It's always that real concern around, are we becoming overly legalised in a lot of this stuff?
I understand.
It's a balance.
Yeah, if you do have a contract in place, it may be that the contract was negotiated some time ago and things have moved on since then.
Yep.
And so it may be that that enforcing the contract may be unfair in some way now because of whatever water's under the bridge. And if you just stick to the contract purely and simply, that might be unfair, or and so if you would take a litigious approach, then you could actually bully someone using the contract, which is not ideal. But that's a reason to have them updated regularly, right? Because then,
which I'm about to say, that gives you the reason that you should, review them and have them reassessed and re-executed, just to make sure everyone's comfortable with the agreements that we've kind of come to.
Yeah. I mean, we had a shareholder agreement just recently that had been in place for many years, and the client went to do their will, and they looked at the shareholder agreement as part of that because their main asset was the business, and there was nothing in there about what happens if they die or they're permanently disabled at all. So the will only deals with personal assets, as we've sort of talked about in previous episodes. The will doesn't deal with company assets, which sometimes surprises people. And so this company has 2 main shareholders, and it's worth a lot of money. And if one of them died or was disabled, then they'd be in business with the
spouse.
The spouse or the children or whoever inherits the shares, if you like, which wasn't the idea.
Yep.
And nobody knew that, and nobody had looked at it for years and years. And in fact, what had happened is there was a company in Australia, but now there's a company in New Zealand, and there's a company overseas in Europe, and there's in fact a couple more companies in Australia. So there's this whole corporate group, and there's only really one document that has a shareholder agreement, which is of no value to them anymore. And there was 2 directors, and now there's 4. So all sorts of things happen.
Yeah.
This company's worth maybe $100 million.
Yep.
So you're talking about a $50 million asset for the two main owners. And so, you know, and you might, to do update all of that might cost you $5,000, $6,000. You know, it depends on what's going on. It might cost more than that. Depends on a bunch of things. But you really, relative to the value of the company and to the importance to the spouse and to the lives of the owners, you're really talking about a small investment, I think,
Yeah. Well, I mean, I've seen a few over the years where it only mentions death.
Yeah.
Like the shareholders' agreement, for whatever reason, it was an older agreement, and it only mentioned what would occur if one of the directors was deceased.
Yeah.
It doesn't pick up, well, what happens if they need to exit due to a terminal illness?
Yep.
Like that could take, that might take them 3 or 4 years before they actually
and they might die, but
they might not be able to work in between. Yeah, and it doesn't, or a total permanent disability. So I think, or the lack of cognitive ability. I mean, that could be an accident, or there's a whole range of reasons. And I agree. I think it's one of those things that people kind of, she'll be right.
Yeah,
we don't need to do that. But also, I think agreements can be, you made the point around estate planning. That is a really important thing, because you can have these commercial agreements.
Yeah.
But a lot of time people won't assess that in alignment to their estate planning requirements.
Yeah.
And because a lot of the time they don't always understand that a will only deals with your personal assets unless there's an instruction that's tied back into the corporate structure. So you've got to make sure the wording on both documents supports the direction that you want to go. Because you may say something within your will that you would like to occur, but the actual document of the company constitution or the trust deed or unit trust doesn't allow that.
Yeah, that's right. It's just a matter of your wishes being properly set out in writing, because if you're ill or you're dead, then you're not going to be around to make them happen. And you have this lifetime, and in this case, this to go back to my example of the $100 million business, we're talking about serious dollars. I can understand the she'll be right attitude if you're talking about, I'm just starting a business with my brother, and we've got zero turnover. You think, okay, well, I don't really want to spend a whole bunch of money with my lawyers, day one. And look, I'd say maybe you should anyway, and if you should be investing in the future of the business, but, that's me. But I can understand that. But, things happen, things get out, as the business grows and life moves on, and you're talking about serious value, you're talking about a relatively small investment for a lot of kind of insurance, if you like, for if one person was ill or died, and in fact the two directors of this particular company, I don't think either of them are in the best health ever anyway. So
but that also goes back to it. You and I could be sitting here having a conversation as directors of a business. So you and I have had these conversations. We might have had it for 15 years, these conversations, and there may be an original document. However, when they go home and talk to their partners at home or their kids, the discussion may be a little bit differently, but the interpretation of that discussion, I thought Alex meant this versus, no, this is actually what it is, and they haven't had that opportunity to have that, explanation provided by either party to say, this is what we would like to see happen. Now we need to get that documented in such a way. So that's how I look at it. I mean, I look at it as agreements as a really positive point of view, because it gives clarity around what it is that you want to occur. It's not just for when things go bad. It's also when people are wanting to progress and transition and move and sell out of an asset or take out another. Like, there's a whole range of different reasons. So it's not a negative. It's actually a much better position to allow people to be very clear around what they would like to see happen. And so you've almost got to cascade through some of the agreements, which are the most important ones, and some will be, well, we'll just let it run as it is. But I do think, you want to go through the various agreements and understand what each one does for you or not for you.
Yeah, it's just part of your broader risk management of the business and your broader good management of the business, right? Even putting aside risk, it's good management so that all your customers are clear what the payment terms are, that all your employees are clear what confidential information they're allowed to take home, or not. What they can, when they finish working with you, what they have to return and what they can, what information they can continue to use or whatever it is. Can they poach customers? Can they wait for a while and then poach your customers? How does that all work? Clarity means you avoid disputes, and then you avoid going to court, and you avoid lawyer fees, and you avoid, stress.
And it really improves your enterprise value.
Yeah, well, that's right.
Because someone looking at your business, if you haven't got things documented, they don't know. Oh, well, there's Alex has got an agreement with Bob down the road.
Yeah.
Well, I don't know that as a potential purchaser of your business, or even a younger director coming in and purchasing. Like, they don't know what some of the agreements are. So that can also be a catalyst if you're bringing in some younger ones and you're transitioning or selling down on part of your business. It's a good time to kind of review all of your agreements through that process as well.
Yeah, I can tell you, if you're trying to raise money, you're trying to get investment into your business, trying to get shareholders in particular, they're not going to jump in unless there's a shareholder agreement, which, gives them minimum rights, unless there's long-term supply agreements, unless there's employment agreements, unless there's, insurance in place. They want to see all of those things, and those things are going to help you raise money. They're also going to help you sell your business. And then also, even if you don't sell your business or raise money, they're going to help you run your business so it's not so reliant on you. Which will make it more valuable and less stressful to operate.
Yep. Because you can always parachute someone else in to do it, because it's like, well, there's my roadmap. That's what you need to do. Yeah. It's funny how these things sometimes they all kind of overlap with one another. Some of these themes that we talk about in different podcasts, like running the business so it's not so reliant on you. Those themes just sort of come through each time, and that sensible business management involves a whole lot of aspects, and one aspect I think is having clarity around the agreements. Yep. Okay. So before we kind of close out the episode for today, Alex, is there anything you'd like to kind of add in there that people need?
Oh, no, only that I think we, you want to look at the different areas that you have agreements and look at the kind of risk overall, and has the risk increased? Are the transaction sizes increased? Has the law changed? Do you know if the law's changed? That sort of stuff, and then just make sensible decisions. I'm not saying you need to review every contract you've got every year, but I think every you need to look at the different areas probably every year as part of your risk management plan, and identify which ones need to be updated, and get a good long-term relationship with the solicitor who can help you through that in a kind of a cost-effective way over the years, as a long-term investment.
Yep. Well said. I agree. I think part of it is just, it is a matter of just understanding what your agreements are and when was the last time you reviewed them, to really give yourself a bit of an opportunity to get sort of stuck into it. All right. Well, what we might do is we sort of close out our conversation today. I'd like to thank Alex again from Taurus Legal Management. And for those that would like to contact Alex, we can either pick him up at LinkedIn at Alex Martin, or via the website at tauruslawyers.com.au. And also, as I talk away, I'd like to thank myself, David Murdoch, the wealth activist from Paxton Bridge. You can also contact me on LinkedIn at David Murdoch, or via our website at paxtonbridge.com. Thank you for today. Show notes will be provided, including our contact details. So once again, Alex, look forward to another conversation, and we shall talk soon.
Thanks, Dave. Thanks, listeners.
See ya.